Hi, I'm Stuart Weems, Director of ProSolution Private Clients, and I'm joined by Jerry, a Senior Wealth Advisor in our business, and we'd like to welcome you to this presentation on estate planning. These presentations are best viewed in full screen mode, and you can activate that just by clicking in the bottom right hand side of the screen as circled here in red. And on the bottom left hand side you can use the controls to play, pause and fast forward the presentation.
So why is an estate plan important? Well, it is important, but there's no urgency about it. Death is often unexpected, and it's important that you make provisions for your family and set clear instructions to assist them with the distribution of assets. It's often been referred to as ruling from the grave. Effectively, it's leaving clear instructions so that you give what you want to who you want and when you want them to have it, and to help children where you don't necessarily have the confidence that they'll be able to manage it or make it last an adequate period of time. So estate planning is important in all cases, but arguably there are some higher risk categories of individuals that require special consideration. So let's have a look at who some of these are. One is individuals with assets in their personal names. This is an important consideration for wealth creation, but also for estate planning, and not just to protect assets, but to ensure that they're distributed efficiently. Secondly, where there are blended families, so a previous spouse, children from a previous marriage, need special consideration. In some cases where the spouse might not be able to or just might not want to manage the financial affairs of the estate, the family, and therefore leaving clear instructions and processes for the management of those is a significant help to that spouse. In other situations, there might be family members with special needs, such as a disabled child, or where the parents anticipate that one of their children might not be reliable, potential concerns about marriage breakup of one of the children, and making provisions for that.
This slide lists some basic estate planning steps that I think nearly everyone should be ticking off. So obviously it starts with a will and potentially a testamentary trust, something we'll discuss in more detail in the next slide. Powers of attorney, which really document giving someone else the authority to act on your behalf should you not be available to sign documentation or should you be ill or incapacitated. A living will, I guess, is similar to a normal will, but looks or gives instructions to carers and loved ones of what should happen in the event that you are critically ill or seriously ill and medical decisions need to be made. Superannuation nominations are also very important, because superannuation isn't or doesn't fall under a will. In fact, a trustee of a super fund can pay superannuation monies as they sort of see fit or they think is best for you. And what some superannuation or most superannuation funds allow members to do is sign a declaration to instruct the trustee to pay the funds to certain beneficiaries. Most super funds want those nomination forms be updated every 3 years, so it's important to keep on top of, and also important you nominate the right beneficiaries as well, because some beneficiaries can receive your superannuation monies tax-free, other beneficiaries will be taxed. Life insurance, a little bit beyond the scope of this presentation, but obviously it's part of an overriding estate plan to ensure remaining family are taken care of. And letters of wishes is also a good one. That's really your instructions to your executor of your will on how you'd like your estate to be dealt with. So maybe if your executor isn't investment property friendly or isn't really wise to how property investment works, you might leave some instructions of what they need to do. They might sell one property, keep the rest, those sorts of things. These are just some basic estate planning things I think nearly everyone should be able to address.
So how often do you need to update wills? This depends on the complexity of your circumstances, potentially the size of the estate, and certainly changes to your circumstances. So it might be, for example, setting up a self-managed super fund or a family trust. We often see clients that have an estate plan, have added structure to their added greater complexity to their structures and haven't accommodated that in their estate plan. It might be going from being a employee dentist to starting up your own practice and making sure that it takes account for those structures as well.
Choosing an executor to your will is a very important decision, and most people just appoint their spouse or brother or sister as their executor, but they might not make the best decisions close to your death. So you need to consider, how will these people cope if you die? What position will they be in? And how much experience do they have managing financial affairs? These are all good questions, but of course you don't want to entrust someone with that sort of power that you don't necessarily know, or then they're not family members. So maybe one way of complementing that is instructing your executors to appoint some advisors. They still make the final decision, but at least they're well versed in doing so. Also, make it easy for your executors. Make sure they know where all documentation, the advisors that you use, details of assets and liabilities, all these sorts of things might save a whole heap of time, trouble and stress in the event of your death, so that at least they know where everything is. A testamentary trust is really a trust that's inserted into a will, and the trust isn't actually created until death. So what happens is, once you die, this trust is created. Often it's very similar to a discretionary style trust, and then beneficiaries are named. The benefit of a testamentary trust is that it gives your executor the opportunity to actually shift assets inside that trust. So, for example, people that hold a parcel of investment properties or shares or so forth in their personal name, and then they die, those assets can then move into a trust. There's some really good planning benefits of doing so. You might be able to stream income and capital to different beneficiaries. You might be able to preserve your asset base and allow beneficiaries to enjoy the income received. Also, underage beneficiaries, so beneficiaries under the age of 18, can potentially enjoy the normal marginal tax rates as opposed to the minor penalty rates for income that might be streamed from a testamentary trust. So there's some really good tax advantages there as well to save tax for beneficiaries. The last thing that needs to be addressed is dealing with companies and trusts. Most dentists operate family trusts, practice trust maybe, service trusts and entities of the like. When it comes to trusts, the most important position there is the appointer of the trust, because they can appoint a new trustee or hire and fire an existing trustee. And so that needs to be dealt with in the appointer's will. So in your will you can appoint a new appointer. It's quite confusing. And with companies, that one can be a little bit more complex if you've got a sole director, sole shareholder company. So if you're in that position, whether you're the sole director and sole shareholder of a company, it's possible that upon your death, the executor of your will won't be able to actually deal with that company for quite a period of time until they can appoint a new director. So what we often recommend is sometimes having a sole director, but two shareholders. So maybe your spouse as a shareholder to a company as well. But some of these issues are quite complex and need individual solutions. Okay, so some advanced estate planning considerations. One thing that we get a lot of clients thinking about is probably protecting wealth that they've built or accumulated before they enter into a new relationship. So things like binding financial agreements, or often referred to as prenups, and what the family court will consider as a de facto or marital agreement. So there's a bit of forward planning there. Protecting at-risk people. So at-risk people are really people that would be at risk to an action by a creditor. So if you're a dentist that also does property development, for example, you've got a different risk profile than, say, an employee dentist. And in that circumstance would probably not want to see too many assets in your personal name. So I guess it's a meshing of both estate planning and asset protection strategies. Blended families or families in conflict. I guess we're constantly reminded by some estate planning lawyers of how mixing finances and families can create quite a lot of conflict, particularly when maybe a key family member dies and that key family member has previously, I guess, led or controlled the family to some extent. So that's something to think about. If your family is potentially subject to something like that, then there are things that we can do prior to death to make those transitions not easier, but a little bit cleaner.
One of the really interesting aspects around estate planning, I think, is around philanthropy. In financial planning, we talk about the challenge of longevity risk, not knowing when you're going to die, and hence having more assets than you need so that you don't run out. Another aspect of that is looking at who else you can distribute assets to outside your family. Now, charitable trusts have inherent tax benefits, but they also allow you, again, to exercise a little bit of control with the assets that you gift to these organisations, rather than handing over a large lump sum with no regard for how that's spent, and it could be spent in a very short period of time, is setting up a charitable trust that has perpetuity and produces income that can assist that charity, that organisation for many years to come.
I'd now like to play a brief interview that I recorded recently with a specialist estate planning lawyer, Lachlan Hughes, that we use in our business. Hi Lachlan, thanks very much for your time today. I guess I'd like to start by asking, what are some of the common estate planning mistakes that you see clients make that tend to cost a bit of money or maybe a bit of stress?
Yeah, hi Stuart. The most common mistakes we see, they can be varied, but to give you an idea, firstly, if a person doesn't have a will at all, that's an important one, where people might get divorced, which automatically revokes a will, and they don't do a new will, and then the laws of intestacy apply, which can have undesired consequences. Secondly, a person may have an out-of-date will. For example, the executors might have passed away since they made their last will, or they might have sold some assets that were in their previous will, so that should be rectified, otherwise the will won't apply in respect of those assets. A very common mistake we come across is where there's a misunderstanding that people think they do a will and that will govern then trusts that they might have set up, or companies and things like that. And that's probably the most common mistake we come across, and we find it generally addressed by dealing closely with the person's accountant or financial planner to make sure that the structures they have in place are addressed. Also, with those types of structures, people may have specific succession plans that they want those trusts to pass to particular people. Often people do a will not realising that they might have to address it in the trust deed or in the company's constitution, for example, to address those things. Another common one is where there are blended families and there can be children from previous marriages that come into being a blended family with a couple that have been married previously. It's quite important to make sure that those interests of the children and the respective spouses are addressed in a new will. Also, some people have a lack of understanding when a beneficiary is left out of a will as to that beneficiary being able to make a claim against the estate. We make sure we explain to the client that there are certain classes of people that you need to make adequate provision for, and if you don't, there's a risk that they could make a claim against your estate. So again, some people desire to cut out people, but they need to make sure that they do it after receiving adequate legal advice. They're probably the main errors that we find, not all the time, but it is important to have those addressed anyway.
That's great, Lachlan. Are there any particular estate planning issues or considerations that need to be addressed by medical practitioners and dentists specifically?
Good point. Probably the main issues in respect of, well, not only medical dental clients, but I guess people in similar professions, being, at-risk occupations, I call them, where their assets can be exposed. It's extremely important to make sure that when passing assets between spouses, that, for example, if the wife is the one that's the dentist and the husband passes away, that all the assets aren't all of a sudden passed to the wife, and then she becomes rich, which can then expose her assets to creditors and of the like. So very